Thank you very much indeed, Nora. With such a wind-up, sure, I could go home now happily and I'd be happy. Talking about things you must be fed up of, I would imagine the Lisbon Treaty must come into that category for members of the Institute. So I'm sorry that my topic is, in fact, data protection, the Lisbon effect. That's because the Lisbon Treaty will actually have significant impact on the area of data protection. And it's happily something which has not engaged the Irish public yet, and hopefully will not before the referendum. So I think it's something we can safely talk about in a non-controversial way. Irish data protection law is based almost entirely on EU legislation. So I'll first describe briefly the current EU legal framework for data protection and how it's transposed into Irish law. I will then describe the changes that are provided for in the Lisbon Treaty. And finally, I'll comment on the future challenges that face us in implementing a more vigorous data protection regime arising both from the changes in law and from the changing environment in which data protection law operates. The present treaties contain very few references to data protection. Article 286 of the EC Treaty simply provides that secondary legislation on data protection will also apply to community institutions and bodies. And this article is the basis for the regulation which establishes the Office of the European Data Protection Supervisor. That's currently Peter Hustings, who has spoken in the past, I know, at the Institute. The Data Protection Supervisor is responsible for overseeing the operation of data protection in the European institutions themselves. Now, also, Article 31b of the Treaty on European Union provides that the processing of police data should be subject to appropriate data protection provisions. However, data protection merits a special article in the EU Charter of Fundamental Rights, which, as you all know, is going to acquire enhanced status under the Lisbon Treaty. I'm going to pause over this slide because I think this article is one of the best summaries that I've come across of what data protection is about. And it says very simply, everyone has the right to the protection of personal data concerning him or her. Such data must be processed fairly, for specified purposes, and on the basis of the consent of the person concerned or some other legitimate basis laid down by law. Everyone has the right of access to data which has been collected concerning him or her and the right to have it rectified. And finally, compliance with these rules shall be subject to control by an independent authority, which in Ireland is the Data Protection Commissioner. I think that encapsulates what can sometimes appear a very complex body of law. So I'd certainly commend it to anybody who wants a summary of what data protection is actually about. The key EU laws on data protection that apply to member states are internal market measures. As is stated in the preamble to the 1995 directive, the establishment of an internal market in which the free movement of goods, persons, services and capital is ensured require not only that personal data should be able to flow freely from one member state to another, but also that the fundamental rights of individuals should be safeguarded. The 1995 Directive on Data Protection is the key data protection measure. It sets out in considerable detail rules on the protection that must be provided to personal data in the member states. It also provides that each member state must have an independent supervisory authority to monitor the application of data protection law. Now, it was decided in 2002 that the General Directive was not specific enough to deal with the new challenges arising from new means of electronic communication. So the 2002 Electronic Privacy Directive applies specific rules in the area of electronic communications. It particularly targets abuse of personal data for marketing purposes. In the area of police and judicial cooperation, which of course is of particular interest to this group, the Council recently adopted a decision on data protection as it applies to transfers of police data between member states. And finally, the separate legal instruments setting up bodies such as Europol and Eurojust contain specific data protection provisions, including independent data protection oversight bodies. European law is transposed into Irish law in the following manner. The Data Protection Acts, there's two acts, 1988 and 2003, they give effect to the basic 1995 directive. Regulations made under the European Communities Acts give effect to the obligations under the Electronic Privacy Directive. Now, in the area of electronic privacy, our laws were recently strengthened in a way that makes it easier for our office to secure convictions against spammers, and also significantly increases the criminal sanctions that apply in this area. The separate European instruments establishing bodies such as Europol and Eurojust are given effect in separate acts of the Oireachtas, and in each case the Data Protection Commissioner is the National Data Protection Oversight Body. Finally, some minor transposition is necessary to give effect to the recent third pillar decision on data protection. The transposition is minor because An Garda Síochána have always been subject to our Data Protection Acts, as indeed have the military forces, even though this is not an EU obligation. Indeed, we have a separate agreed data protection code of practice with An Garda Síochána, which covers the processing of personal data by An Garda Síochána. So, in summary, while there is a significant body of EU law governing data protection which is transposed into Irish law, it applies mainly in the internal market area, with patchy coverage in the third pillar area and nothing at all in the area of the second pillar, common foreign and security policy. So I now turn to the changes that will be brought about if the Lisbon Treaty comes into effect. The most significant change is that data protection would be elevated to the status of a binding treaty obligation. The new Article 16 of the Treaty on the Functioning of the Union provides that everyone has the right to the protection of their personal data. This right is formulated in such a way that it has direct effect. So, in the sense, it is comparable to other rights given under the EU treaties, like, for instance, the rights of the EU citizen to move and reside freely within the territory of all the member states. Now, the article, as you can see, goes on to provide that the Union must lay down rules which apply to Union institutions, but also to member states when carrying out activities within the scope of Union law. It also provides that compliance with the rules must be subject to the oversight of independent authorities. Now, the article is horizontal in effect since, as you all know, the Lisbon Treaty abolishes the current pillar structure, at least formally. However, there are special provisions applying in the area of the common foreign and security policy and also in the justice and home affairs area. In relation to data protection in the CFSP area, the requirement is for the Council alone, not the Council and Parliament, to adopt a decision laying down the rules when member states are processing personal data when carrying out activities which come within the scope of CFSP. Now, at first sight, it might seem that CFSP is far removed from data protection. However, it must be borne in mind that binding sanctions, for example, against alleged members of Al-Qaeda are applied in the context of a CFSP decision at present. The interference with individual rights involved in the implementation of such sanctions is quite significant and has given rise to controversy, including a judgment of the European Court of Justice, the so-called Cadi judgment. The new Article 16 does, however, apply to justice and home affairs. It applies fully in the area of police and justice cooperation. However, declarations attached to the treaty require the Union legislators to have regard to sensitivities in this area when adopting new Union laws. So Declaration 20 refers to taking account of the specific characteristics of national security and recalls that the present Data Protection Directive has derogations covering this area. The derogation is in Article 3.2 of the 1995 Directive. It provides that the directive does not apply to, and I quote, processing operations concerning public security, defence, state security and the activities of the state in areas of criminal law. There's also a transitional period of 5 years provided for in Protocol 36, during which existing provisions in this area will still apply. Declaration 21 indicates that specific rules may be needed in the fields of judicial cooperation and criminal matters and in police cooperation. And finally, Protocol number 21 is a reminder that the UK and Ireland have a right of opt-out in the area of judicial and police cooperation, and that data protection rules adopted at the EU level will not apply to the opted-out areas. So in summary, if the Lisbon Treaty is approved, data protection will have enhanced status in the Union's legal order. This will be reflected in a specific treaty obligation, in the enhanced status given to the existing Charter of Fundamental Rights, and in particular its Article 8 dealing with data protection, and in the fact that data protection rules will apply across all areas of EU activity. I would now like to, as it were, step back and look at some of the changes in data protection that are happening and are likely to happen in the future. These are likely to arise both from the environment in which data protection operates at present and the likely changes in the legal regime laid down at EU level. We're living in a world where, thanks to information technology, the amount of personal data being gathered and stored by organisations, both private and public, is increasing exponentially. And again, thanks to information technology, personal data flows internationally in a way that does not respect political borders. For example, when you use your credit card, the merchant may be in one country, your account might be in another, the processing of the transaction might be in yet another country, and finally the call centre to deal with your inquiries might be in yet another country. So how do you ensure that the high standards of personal data protection that apply in the EU also apply when that data moves outside the EU borders? The amount of personal data being held by organisations is also giving rise to increased concern about the adequacy of the security measures surrounding such data. Well-publicised data breaches, including unfortunately in Ireland, have increased public concern. The extent of state use of personal data is also coming increasingly into focus. What is the proper balance between sharing data in the interests of efficiency in the public sector and respecting the wishes of the individual citizen? To what extent should we collect or should we tolerate increased state surveillance of the activities of the innocent majority so as to make it easier to deal with crime? And last but not least, since data protection is fundamentally about giving the individual control over the use of their personal information, what types of personal information is it most important to protect? Now, perhaps surprisingly, a Eurobarometer survey last year suggested that Irish people were significantly more concerned about data protection than people in the EU in general. A survey we commissioned ourselves in 2008, that's before cuts ruled out any such activities, but in those golden days of 2008, the survey suggested that privacy of personal information came third after a good health service and crime prevention in the eyes of Irish people. And when asked what aspects of personal privacy was most important to them, it was perhaps not surprising that medical and financial data came top of the list. But it may be significant that much of the categories of data that people were most concerned about are categories held by the state, including medical records, but also the PPS number, which figured more prominently in what people were concerned about, and Garda and social welfare information. It was also striking how little confidence Irish people had that the public or private sectors could be trusted to adequately safeguard the security and confidentiality of personal data. Only about half of the respondents were confident that they could trust organisations to respect the security and confidentiality of their information, which I think is a rather depressing statistic for any organisation handling large amounts of personal data. Reflecting widespread public concern, we are already seeing change happening in the area of data security. Last year, our Department of Finance produced detailed guidelines on data security in conjunction with our office. Adherence to these guidelines represents best practice in this area. Also last year, Minister Ahern established a working group to examine a possible need to legislate changes to deal with data breaches. The Minister's initiative followed publication of a private member's bill which provided for mandatory reporting of significant data breaches. The group set up by Minister Ahern, which I'm a member of, should report later this year. The revised directive on electronic privacy, which is at the final stages of the EU legislative process, contains an obligation to report serious data breaches both to supervisory authorities, that's data protection authorities, and to affected individuals. And as part of the legislative package, the Commission agreed to examine the case for a broader data breach requirement in EU law. There have also been moves at EU level to further facilitate the safe movement of personal data of EU residents when that data moves outside of the European Union. The system of model contracts for data transfers outside of the EU has been further simplified recently, and specifically to meet the needs of multinational companies, a system of binding corporate rules has been developed. Now, this essentially involves approval of transfers outside of the EU based on binding commitments contained in the company's internal privacy policy. There's also been a significant development in the approach of our own office to our duties under EU and national law. We continue to deal with the passive aspects of our role, that is, handling complaints from members of the public and maintaining a public register of major holders of personal data, such as the state itself and financial institutions. But the greater part of our resources is now devoted to seeing that data protection law is being respected in practice and to trying to improve the overall standard of data protection in the country. We've been making full but selective use of the powers granted to us by law. Recently, we've had a number of successful prosecutions against companies in the SMS sector for text spamming. And this has had a very salutary effect on the sector, and we've seen a significant reduction of complaints in this area. We had adopted a similarly targeted approach 2 years ago to new phone company entrants to our market who had been annoying many of us with phone calls urging us to change provider, ignoring the national no-call list. So we were happy to work together with the communications regulator to basically warn these companies that if they did not stop between us, we had the power to put them out of business and would do so. So abuse in that area has stopped. We've also been devoting significant resources to our audit function. We use the learning from audits and from complaints to develop better guidance material and, where necessary, codes of practice. And in the last 3 to 4 years, we've been able to approve codes of practice for An Garda Síochána, the insurance industry and the Injuries Board. Turning again to the EU area, the recent Commission communication on the Stockholm Programme anticipates the entry into force of the Lisbon Treaty by stating that the Union must develop a comprehensive data protection scheme covering all areas of EU competence. It also acknowledges that in a world where data is flowing freely, there is a need to develop international standards if the personal data of EU residents is to be appropriately protected. I know the programme was on the point of being adopted when Jonathan Fall spoke to you last June. So it now has been adopted, and that extract is from it. The Commission has already commenced the process that could lead to a comprehensive EU data protection regime covering all of the traditional 3 pillars. Their approach was helped greatly by a critical study commissioned by the former UK Information Commissioner Richard Thomas, who had suggested that there was too much complacency at EU level about the quality or the durability of the present EU legal framework. So, following a conference in May organised by the EU Commission, the Commission is at present engaged in a public consultation exercise which could see a revised directive in place in a few years' time. There have also been moves at EU level and in other regions to develop global privacy standards, including in the very broad APEC, Asia-Pacific area. The draft privacy standard developed recently by the International Standards Organization is quite significant, coming from a standards body, and also a draft standard likely to be approved by the forthcoming Conference of Data Protection Commissioners in Madrid is also quite significant in this area. It demonstrates, I think, that a variety of organisations coming from different perspectives recognise the need to try to come up with standards that apply globally to match the fact that personal data is flowing globally at this stage in a way that is very difficult to control. There's also been significant private sector activity, particularly through the US-based International Association of Privacy Professionals. Also significant is a project on accountability of data controllers, which was supported by major multinational companies. Now, in view of the importance of multinational companies in our economy, our office has been devoting significant resources to facilitating developments that permit such companies to move personal data safely to non-EU jurisdictions, This included hosting the accountability project meetings in Dublin Castle earlier this year, as well as having regular meetings with companies, multinational companies, to guide them on compliance issues in the data protection area. We have regular contact with multinational companies, and we certainly tell them that we're very happy to act as sounding boards for how some of new proposals they might have, how they might work or how they might adjust them to better work with the European Union's data protection regime. Finally, I would like to come back to some of the issues that have to be faced when looking at a future horizontal EU data protection regime. One of the criticisms of the present EU regime is that it is too prescriptive and encourages an approach of mechanistic compliance with rules rather than focusing on what level of data protection an individual should expect from a particular organisation. Now, to be fair to the EU law, the criticism should be more accurately, in many cases, addressed to the member states and to the gold plating, as it were, of some of the transpositions of the data protection directives, because in fact the data protection directives are very much principles based, but in their transposition into national law, some member states, I hope we're not among them, but I'm not the legislator, some member states certainly would have imposed quite bureaucratic requirements which perhaps are not necessary to fulfil the spirit of the directives. You could ask, in looking at a new regime, is there a case for giving organisations more leeway in this area, based on being more transparent about their policies and being more willing to be held to account for any failures? The data protection rules are technology neutral. Nevertheless, there's a constant challenge on how they should apply in contexts such as the internet and social networking. And particularly those of us who have teenagers might wonder about what the current generation's view of privacy is if you look at some of the stuff that our teenagers share on the internet. Not that I monitor our teenagers' activities, but I am told that it's pretty hairy stuff. Anyway, ideally, privacy should be built into technologies rather than dealing with privacy implications after the event. And indeed, in the area of social networks, it should mean, for example, that our teenagers, and ourselves for that matter, should be warned that when we put stuff up on a social networking site, it tends to stay there. And it could be looked at by people you mightn't expect. I recall one day when I was on our help desk, there was a call from a lady who was most upset because her employer had called her in and said she had noted on her Bebo page, which was quite open, that she'd been at a party the night before, but she was supposed to be sick that day. So we had to tell the lady that, I'm sorry, but data protection doesn't protect you when you do something like that, and you choose to put your activities on a social networking site. So there you are. So turning to more serious things, the appropriate balance in the area of state use of personal data will continue to be very challenging, because whereas I have described many of the encouraging developments at EU level, also coming out of the EU are quite challenging proposals, particularly in the area of justice and home affairs, which significantly restrict the individual's right to protection of their personal data. And finally, and hopefully positively, the pressure will remain on data protection authorities to work smarter in order to discharge their duty to monitor and uphold data protection standards. So thank you very much for listening to me. Thank you very much, Bily.